thorough answers to the comments. And if we are in agreement, I would suggest, because we are a little bit behind on time, that we start the next panel, and probably at the end of the next panel we will find a little bit of time to have a small pause, because we will need it. We don't want to go non-stop, but I don't want to delay the chair and the panelists of the next panel. So let me introduce Professor Emeritus Petros Stangos, who is an Emeritus Professor at the Faculty of European Law at the Faculty of Law, Aristotle University of Thessaloniki. He is also the Director of the Center of European Legal Culture of the Aristotle University of Thessaloniki, and a member of the Governing Board of the Kalliopi Koufa Foundation. Professor Stangos, thank you very much for being with us today, and I give you the floor to chair the next panel.
Mute. So, thank you very much, Vasilios, for this invitation. I want to welcome you to this second panel of the conference on the EU responsibility in the international system. The topic of this panel is the evolution of the internal mechanism of the EU liability and its interaction with the DARIO. I'm not an expert on liability under public international law, but I know very well that non-contractual responsibility under EU law has long been, and to a certain extent still is, a juristic jungle. Orientation and structure are not easily accessible in this abundance of case law. At its core, one principal ground of liability can be identified, though its contours remain blurred: breaches. But on the edge, in the shadow of this topic, other independent grounds of non-contractual responsibility of the Union exist. One of them is, of course, the non-contractual responsibility of the EU for acts and omissions of its organs and employees. So the first report within this panel has to do with the internal mechanism of EU liability. It will be presented by Mrs. Kathleen Gutman. The second report has to do with the attribution of conduct in EU public liability law and the ILC articles. This report will be presented by Professor Melanie Fink. Mrs. Gutman is a referendaire in the chamber of the Advocate General of the European Court of Justice, Mr. Tanchev. Mrs. Fink is an assistant professor at the Europa Institute of Leiden University. I want to ask you to respect the time you have at your disposal, 20 minutes, each of you, and in a completely democratic way, I decided to give the floor to the participants in this conference after the end of the second presentation. So, Mrs. Gutman, the floor is yours.
Thank you very much. Can everyone hear me? Good. Yes. Okay, I'm going to share my screen now. Hold on. Hopefully, can everyone see that? No. Hold on. Let's see. Ah, voilà. Sorry, my mistake. Actually, I'm trying to figure out how to share it, actually.
do you need us to help you? It's the share screen button.
Yeah, I'm trying to do that
Yeah,
now.
now
Okay.
we can see, but I can see myself. So let me.
Let's see. Can we see that? No.
Yes. Okay.
Ah, fantastic. Can we see this? Are you seeing?
Yes, yes.
Fantastic.
Okay.
It for some reason doesn't show up on my screen, but okay. So are we? Good evening, everyone, colleagues, distinguished guests, ladies and gentlemen. Before I begin, I cannot see any of you, but I hope that you can see me. Yes.
Yes, yes, we
Okay.
can see.
Okay, I am truly delighted to be here today, virtually at this inaugural conference, to discuss the internal mechanism of EU liability. Voilà. Before I begin, I would like to thank Vasilis and the organizers for inviting me to participate in this conference involving so many exciting aspects relating to the EU's international responsibility. I should also mention that this presentation is solely my personal opinion. Now, by way of introduction, since the founding of the European Union, the governing treaties have expressly provided for parties to bring a claim directly before the Union courts at the EU level, that is to say, before the General Court at first instance with appeal to the Court of Justice. And this is in order to establish the liability of the Union and obtain compensation for the damage allegedly caused by the Union through its institutions and bodies. Claims involving the Union's non-contractual liability are generally concerned with all kinds of unlawful acts and conduct allegedly committed by the Union's institutions and bodies. These claims are commonly referred to as actions for damages against the Union and are governed by Articles 268 and the second paragraph of 340 of the TFEU. Now, in the EU's internal system, there are also other types of procedures on the basis of which parties can seek damages from the Union. In particular, claims involving the Union's contractual liability are generally concerned with disputes based on a contract between a Union institution or body and a third party. These claims are governed by Articles 270 and 272 and the first paragraph of Article 340. And as we will see, may sometimes, but not always, be brought before the Union courts. Now, indeed, the EU's liability regime, in particular the action for damages, is extraordinary because it has so many important tasks in the Union legal order and intersects with so many areas of EU law, and not to mention international law. So, for example, the action for damages is what distinguishes the EU from international organizations whose rules traditionally confer extensive immunity from suit. The action for damages crosses the divide of public and private law and ventures into the realm of comparative law through the reference in Article 340 TFEU to the general principles common to the laws of the member states, on the basis of which the Union courts formulate Union non-contractual liability rules. The action for damages is also the only procedure mentioned in the Charter of Fundamental Rights of the European Union, which has been elevated to binding treaty-level status with the entry into force of the Lisbon Treaty. And of course, damages actions are an essential part of the overarching EU system of judicial protection, which generally comprises the various procedures that may be brought before the Union courts and the relationship between EU law and the member state procedural and remedial frameworks. Therefore, taking account of recent developments in the case law of the Court of Justice and the General Court, this surely is an opportune time for engagement with this topic. My aim today is therefore to discuss, in light of the Union Court's case law, the main points governing Union liability, at least some of them within the time I have, along with certain key issues going forward. And in this way, I hope that you may then glean the foundations underlying the EU internal system of liability in our discussion. My presentation is divided into 3 parts. First, I will say a few words concerning the context of EU liability with regard to the jurisdiction of the Union courts and aspects relating to the EU's common foreign and security policy within the system of EU judicial protection. Second, I would like to discuss certain key facets of EU non-contractual liability with regard to its scope, the parties, and the main conditions to be satisfied. And then third, I will address some salient aspects and differences with regard to union contractual liability. Now, to begin, although this conference speaks of the EU's international responsibility, when it comes to the EU internal system, reference seems to be made more often to liability, and the terms contractual and non-contractual liability are mentioned in Article 340 TFEU. There are also a number of related terms in the literature, such as EU public or tort liability. But still, these notions of union non-contractual and contractual liability are valuable for delineating the jurisdiction of the union courts. When it comes to union contractual and non-contractual liability, there is an important distinction made in the case law, as highlighted in the Sistran case. Damages claims based on union non-contractual liability fall within the exclusive jurisdiction of the union courts under Article 268. Whereas when it comes to union contractual liability, the union courts only have jurisdiction to decide these claims when there is a so-called arbitration clause, meaning a clause conferring jurisdiction on the union courts. Otherwise, those where there is no such arbitration clause, the claims fall within the jurisdiction of the national courts, as provided for in Article 274 TFEU, as you see on this screen. And therefore, as indicated in the literature, this idea behind the distinction between union contractual and non-contractual liability appears to be that situations involving union non-contractual liability entail passing judgment on union policy. So it was agreed that the union authorities should not benefit from any sort of immunity as regards their non-contractual liability, but that decisions should not be taken in this regard by the national courts. Also, there's a specific provision, Article 270, which governs actions for compensation arising in staff cases, meaning employment disputes between the union and its staff or its employees. Recent case law has in fact highlighted issues bearing on this distinction between the union court's exclusive jurisdiction to rule on actions for damages versus the other procedural routes available in the treaties for ensuring judicial protection for applicants in disputes with EU institutions and bodies. And a salient example of this is the recent case involving the EU Satellite Center, in which the court emphasized that the concept of non-contractual liability has an autonomous character and must, in principle, be interpreted in light of its purpose, namely that of allowing an allocation of jurisdiction between the union courts and the national courts. Also note in the pending case of OH, this involved a reference for a preliminary ruling from a Greek court in which raised issues of immunity of commission members from legal proceedings. And in his opinion, Advocate General Bobek underlined that in this case involving union non-contractual liability, this must be brought before the union courts, whether it's based on Articles 270 or 268 TFEU, and not the national courts. Now, as already mentioned in this conference, there are challenges when it comes to the EU's common foreign and security policy. Although the 10-year anniversary of the Lisbon Treaty is behind us, the union courts are still in the process of working out some of the key changes brought by that treaty that impact on EU liability actions. And this particularly includes aspects relating to the CFSP. This is because the union court's jurisdiction continues to be restricted. Although, as we know, there are certain exceptions laid down in the treaties, one of which involves review of the legality of restrictive measures against private parties. And as we can see, the court's case law on actions for damages against the union has exploited this exception to the max. And as mentioned already by the previous speaker, this is seen, for example, in the judgment regarding Bank Refa, in which the Court of Justice ruled that since the union courts have jurisdiction regarding actions for damages as far as they concern restrictive measures provided for by EU regulations, the union courts must also have jurisdiction to rule on actions for damages based on restrictive measures provided for in CFSP decisions. And this was to avoid a lacuna in the judicial protection of natural and legal persons. But that being said, apparent gaps in the system of judicial protection remain in this context. And this was spotlighted by the judgment in Tomovic and others versus the European Union, in which the English High Court of Justice dismissed several claims based on fundamental rights violations brought against EULEX Kosovo, a civilian mission in the Common Defense and Security Policy within the CFSP. This judgment drew attention to the apparent lack of the Union Court's jurisdiction over actions for damages in the CFSP context, outside that regarding restrictive measures. Now, moving along to union non-contractual liability and the main facets of who, what, and how. First, regarding the parties concerned. So far, we see in the case law applicants generally are natural or legal persons, not yet member states, but there is no restrictions on nationality. As regards defendants, and here's where the conference really is interested, formally, the action for damages concerns the non-contractual liability of the union, but it is directed at the particular union institution or body to which those acts or conduct are attributed. And therefore, it is that institution or body that represents the union before the union courts. Now, this typically concerns the various union institutions, which now, post-Lisbon, include, for example, the European Council, the Commission, the European Parliament, the Court of Justice of the European Union, and the Court of Auditors. Note, with regard to the European Central Bank, in view of its legal personality, there's a separate provision in the treaties concerning its liability, which basically is mutatis mutandis from the second paragraph of Article 340. Also, as regards the Court of Justice, the court has recently held and established that a sanction for a breach by an EU court of its obligation to adjudicate within a reasonable time under Article 47 of the Charter is an action for damages against the union. And note that the possibility of bringing actions for damages against the union courts on other grounds was sidelined in the case of Ori Martin and therefore awaits for future case law. Now, all kinds of union bodies, offices, and agencies are also covered under union non-contractual liability, but particular aspects and complexities may arise. For example, in the recent case of Christos Tomidis, the court held that the Eurogroup, composed of finance ministers of the Eurozone member states who meet informally to discuss matters related to the euro, could not be classified as an EU body for the purposes of union non-contractual liability. But yet the court emphasized that parties can still bring actions against the Council, the Commission, and the European Central Bank in respect of acts or conduct that those institutions adopt following political agreements taken in the Eurogroup. Also note the pending case regarding EULEX Kosovo, which I mentioned is an EU civilian mission in the Common Defense and Security Policy. This case involves a dispute brought by international contract staff and raises questions regarding the attribution of responsibility for the head of mission of that civilian mission versus the Council, the Commission, and the European External Action Service in the years before that EU mission was granted legal personality. And thus, this may invite, following from the question in the previous this panel, invites possible reflections with the draft articles on international responsibility, and especially regarding the concept of agent. Now, moving to the scope of the action, The scope of union contractual liability, it should be noted, has been interpreted broadly to cover situations not only including unlawful acts and conduct, but also those in the absence of such, involving unjust enrichment on the part of the union, as seen in the judgment involving the Czech Republic. Also note that, generally speaking, it was assumed that acts and conduct were attributed to the particular institution or body fell within the scope of union law. Yet recent developments, involving the financial crisis, this has become a controversial topic, especially raising questions in the context of actions for damages. And as we see, an example of this is the Leiden advertising case, which involved actions for annulment and damages brought by depositors of Cypriot banks in connection with the Memorandum of Understanding concluded with Cyprus under the European Stability Mechanism Treaty. This treaty is an intergovernmental treaty concluded by the Eurozone member states outside the EU legal framework. Here in its judgment, the Court of Justice found that although the ESM Treaty Acts fell outside the EU legal framework, this did not prevent unlawful conduct linked to the adoption of a Memorandum of Understanding on behalf of the ESM from being raised against the Commission and the ECB. Now, of note, and this is interesting for our discussion, in his opinion, Advocate General Wall took a different line, reasoning that since the EU institutions were performing tasks outside the EU framework, their alleged conduct should be viewed through the lens of public international law, and found the draft articles on the responsibility of international organizations to be a source of inspiration here. So this has in fact come up, but as we discussed, not yet in the case law, only in the opinion of the Advocate General. Now, moving to the main conditions that must be satisfied. Generally, these three main conditions relate to unlawfulness, causal link, or causation and damage. First, with regard to unlawfulness, recent case law indicates that both the aspects that there must be a sufficiently serious breach of EU law and that breach must relate to a rule of law intended to confer rights on individuals. In other words, both aspects are claiming the spotlight. As we can see from the East-West consulting case, when it comes to conferring rights, this is not only where the EU law rule has direct effect, but also where this rule is intended to protect the interests of individuals, or is deemed to protect both general as well as individual interests. In that case, involving the principle of institutional balance pertaining to the horizontal division of powers between the institutions, well, that was not intended to protect individuals. The position was different, where the rule is accompanied by breach of substantive provisions of EU law that are intended to confer rights, which was the case with regard to the principles of the respect for the rights of the defense and the presumption of innocence. Also bear in mind, the applicant must be among those to whom the rule in question confers rights. And this was demonstrated by the judgment in Dali v. Commission, where the union is not liable for possible breach of the right to privacy and confidentiality of the communications of third parties whose conversations have been listened to and recorded, but not involving the applicant. It is worth noting also that recent general court case law has suggested a possible extension of this conferring rights requirement in these cases involving Industria Chimica, that this may likely also relate to not only conferring rights, but also rules that are likely to lead to the imposition or strengthening of obligations on individuals. But ultimately, the General Court did not deal with this in detail, and these cases are now on appeal before the Court of Justice. Moving to the sufficiently serious breach requirement, as the court has repeatedly held, this requirement stems from the need to strike a balance between the protection of individuals against unlawful conduct and the leeway that must be accorded to the institutions in order not to paralyze action by them. This condition was squarely at issue in the case at the very bottom of the slide involving the European Ombudsman, in which the court emphasized that only a sufficiently serious breach and not merely any breach was sufficient or capable of engaging union liability. Also, as highlighted in that case, union liability rests on the discretion given to the union institutions and bodies, along with various factors such as the field, context, and circumstances of the case. Moving to the other two requirements, in a nutshell, union courts require a direct causal link between the act or conduct and the damage alleged, along with the fact that the damage must be shown to be actual and certain. So as with the other conditions, the inquiry largely depends on the circumstances, but recent case law, such as the Guardian Europe case, shows that the union courts take seriously the directness of the causal link and the fact that the damage must be directly attributable to the unlawful acts and conduct of the institutions and bodies and not the consequence of the applicant's own decision. Moving to my last point regarding union contractual liability, in brief, 3 points stand out. First, with regard to the EU system of judicial protection, here we have the same relationship between the procedural routes in the treaties and union liability, which is arising in recent case law. Here, it's important to recall the distinction regarding union contractual and non-contractual liability, which essentially means that unless there's an arbitration clause conferring jurisdiction on the union courts, various cases involving union contractual liability are decided by the national courts and never reach the union courts unless, for example, by way of a preliminary reference. Regarding jurisdiction of the union courts, as my second point, union contractual liability is likewise subject to the same limits placed on their jurisdiction. So as regards to the CFSP, there's not been discussion yet in the case law or the judgments of the court, but this has recently been mentioned at least in AG Tanchev's opinion involving Ulex Kosovo again. And finally, with regard to the applicable law, it is national law here and not EU law, which is the basis for liability. Generally, the substantive national law applicable to the contract. And the union courts so far have been reticent about formulating rules of contract law based on the general principles common to the member states, as in the case of union non-contractual liability. But note, in the recent cases of ADR Center and Inclusion Alliance, the courts have made clear that when they have jurisdiction under an arbitration clause, they are free to examine any infringement of the Charter and general principles of EU law. So to conclude, in light of the foregoing discussion, assessment of the internal mechanism of EU liability depends on the perspective. From the international law standpoint, EU liability may be considered extensive, whereas from the EU law standpoint, it may not be going far enough. In fact, in the EU law context, one may detect a tension between the principle and the practice of EU liability, especially when it comes to actions for damages. In principle, there is an important role to be played by these actions in the EU system of judicial protection. But in practice, challenges associated with their use remain, whether it be high hurdles for satisfying all the various conditions and the apparent gaps in respect of the CFSP. Nevertheless, recent developments in the case law may be considered to demonstrate the Union Court's intention to maintain a balanced approach and one that ensures that EU liability claims continue to provide effective judicial protection for private parties. At the same time, there are several issues that remain ripe for further investigation. These include, in particular, possible engagement with public international law rules and the draft articles in the case law, for which pending cases offer some possible opportunities. In this way, it will surely be exciting to see how the internal mechanism of EU liability will evolve in the years to come. Thank you very much.
You're welcome. Really, thank you very much for your exhaustive report. It was an excellent lecture. And I have a question about the case law, but I prefer to make the point after the second presentation. So, Mrs. Fink, Professor Fink, you please.
Thank you very much. Good afternoon, everyone. It is a real pleasure to be here today. since I consider myself an international lawyer and an EU lawyer, this is really a wonderful place to be here. I will share my presentation now as well. Hope it works well. You should be now seeing my presentation, do you?
Yes.
Yes. Okay, perfect. So yeah, I will be talking today about attribution of conduct in EU law and how these rules relate to the ILC articles. Now, I will start with a pretty basic observation, yet a really important one, I believe. And it is, for some reason, my PowerPoint, yeah, now it's moving. It is that the rules on attribution of conduct do not get the same attention in EU law as they do in public international law. As this conference also proves, attribution of conduct, there is of course generally applicable rules in international law, and there is a lot of academic discussion on them. In EU law, there is no generally applicable set of rules, so it's sort of pre-ILC. Entity, we do need attribution rules. Generally, they were developed very much on a case-by-case basis, and they differ from area to area. And this, I think, is a very important point because it comes back to Vladislav's and Asa's conversation. The court did not, or at least not usually, rely on the ILC articles. So what I am going to do now, or what I have done and what I would like to share with you, is what attribution rules the Court of Justice has developed specifically in the area of EU liability law. I'm in this privileged position now that attribution of conduct has been explained and liability, so I can dive right into it. And I want to look how they compare to the ILC articles. And I'll start by just saying a few words on the function of attribution of conduct in EU liability law, and then sort of the general rule the court applies. But I'll keep both of these points very short because I would like to spend most of the time on the rule on attribution of member state conduct to the EU. And I'll close with some reflection on the rules that the court develops. So let's start with the function. Now, as this is the case in many other areas too, attribution of conduct rules have a substantive and a procedural dimension in EU liability law. Substantively, attribution of conduct is a precondition for liability. The EU is only liable if conduct is attributable to it. It's only liable for its own conduct. More interesting is the procedural aspect because, and Kathleen has already referred to this, the Court of Justice is competent only to rule if the liability of the Union is at stake. When the liability of the member states is at stake, it falls to the national courts to decide that. That means that attribution of conduct is also a precondition for the court's competence. And that in turn means that it has to be dealt with at the admissibility stage of liability proceedings. Having said that, the court does not always do that. There is not, I suppose it has to do with the fact that there is not really a very well developed theory on attribution of conduct, that it sometimes appears in the admissibility section where I would expect to find it. On other occasions, it is actually dealt with sort of under the causation heading. We can go into that, but somehow there are cases where you have to strongly suspect that the court mixes up what Antonius wants us to not mix up, attribution of conduct and attribution of responsibility. I am emphasizing this because it makes it sometimes pretty hard to actually identify what the court meant to be an attribution rule and what the court meant to be some sort of substantive threshold for liability, like a causation threshold. Okay, having said that, let's move on to the next topic, attribution of conduct to the EU. So sort of the basic rule. Now here, this is the only part where we actually have some sort of basis in the treaties, because the article that Kathleen already referred to, 342 of the Treaty on the Functioning of the EU, the basic, the only article that deals with liability of the EU, says that the EU incurs liability for conduct, and now this is important, by its institutions and servants. Now, institutions is relatively straightforward, even though there is also has also given rise to some discussions. But who are these servants then? Who are these servants? Now, the court has interpreted that very strictly, actually, and has basically limited it to contractual staff. And what is more, the conduct of these servants is only attributable to the EU if they act in the performance of their duties. And this the court has interpreted as sort of an objective threshold. So only if they objectively perform their duties can the conduct be attributable. It does not really depend on how the person subject to this conduct would perceive it. Now, if we compare this to the relevant articles in the DARIO, it's on the one hand Article 6 that Antonius already referred to, which speaks of organs and agents, so covers not just sort of the legal relationship between the international organization and the organ or the agent, but also personnel or persons that are factually controlled by the organization. So it is broader. Also, the threshold of when a person acts in official capacity is broader under the ILC articles, because it also matters what the person subject to the conduct can reasonably believe, whether, if I can reasonably believe that someone is acting in an official capacity, that also sort of counts. Now, I would just like to sort of, on a more a side note, I mentioned already in the beginning that the court does not really refer to the ILC articles when it develops these attribution rules, and I'll come back to that in relation to member states and the EU. But there is kind of one exception or a half exception. It concerns the area of member state liability. Now, that is something that's not based on the treaties. The court has established basically that also the member states are liable for when they breach EU law, not just the EU. And it follows pretty much the same principles. And when the court had to decide on private conduct, when private conduct is attributable to the member states, it did allow that the perception of the person subject to the conduct can be taken into account. And it did not explicitly refer to international law here, but the Advocate General, who sort of advises the court on what decision to take, and the court in that case followed this advice, the Advocate General extensively referred to international law, including the ILC articles. What I find very interesting about this is that in this case, the court actually chose somehow to not base this threshold on 340 EU liability, but rather on international law, even though now, as I'm saying it, it did not explicitly base it on international law, but it was somehow inspired by it through the Advocate General's opinion. Okay, with that, I would like to move on the, for me, most interesting question, which is the attribution of member state conduct to the EU. Now, this is really an area where there is absolutely no sort of written rule or basis that the court could rely on. So what I did to try to find some sort of implicit attribution rule in its case law is that I specifically looked at areas of shared administration. So where somehow in the implementation of EU law, an EU body, usually the Commission, and the national authority share some sort of task, and then see how the court dealt with these cases with the final outcome, who did it attribute it to. So an example for that, a very early example actually, is the agricultural sector, where you have often the Commission with that would sort of advise the national authority how to apply EU law, whether to turn down an application for some refund or an application for a subsidy, things like that, or to grant the subsidy. So what I was interested in, the applicants that brought these cases against the EU, that, for example, wouldn't get a subsidy, they argued that, even though they were refused their subsidy by the national authority, this should be conduct attributable to the Commission, because it was the Commission who, in fact, advised the member states to take this conduct. So the court, though, disagreed in all these cases with this argument. It basically said that because these are advices and they are non-binding, it does not make member state conduct attributable to the EU. There is only one situation where this is different, one exception sort of, which is when it's not an advice, but when the member state authority is legally obliged to follow the advice. So when the advice is not an advice, but an instruction, an obligation. Now, so in essence, the court developed an attribution rule based on legal decision-making power, normative control. If we compare that, and this, I can be rather quick on this because Antonius has thankfully explained this already so well. If we compare this to the ILC's rule, the corresponding one would be in Article 7, which makes member state conduct attributable to the international organization if the international organization exercises effective control, which is understood as factual control. Now, this is interesting, I think, for several reasons. If we think about which threshold is stricter, higher, I think you cannot really say either of them is higher. They are different, and they are different depending on the situation they apply to. So I'm really grateful to Antonius, who has brought this example with the Security Council resolution implemented by an EU regulation implemented by a member state. And it would not, the conduct, the final conduct there would not, as he explained, be attributable to the organization because it is normative control, not factual. So that particular conduct is not captured by the ILC's rule, but it is by the Court of Justice's rule. What is not captured, though, or where where it is stricter, though, the Court of Justice's rule, is where an organization exercises more factual power than legal power. And I want to emphasize this because when I think of the EU, it is not necessarily, I keep referring to Antonius, but it is super useful that he brought up all these examples. So in Antonius's world, the international organization mainly acts through law. But I believe that in the EU, it is quite different because in many areas, the EU exercises a lot more factual power than legal power, even though it is typically described as the organization that acts through law. And I'm specifically referring to Professor Pasivirta has already mentioned Frontex. That is a perfect example of this, operational conduct. But I also think of all these areas where the EU has established, for example, a lot of agencies, or the Commission has acquired a lot of expertise, and they cooperate with member states in the implementation of EU law. Now, even if something then is an advice by the EU body, it carries a lot of weight due to the expertise of the EU body that in these cases often exceeds by a lot the national authorities' expertise on the question of implementation of EU law, so that the discretion that is legally left to the member states often becomes somewhat meaningless. So in these areas where the EU exercises more factual power than legal power, this rule doesn't capture that. So this is what I wanted to emphasize here. It's a different threshold, but not necessarily stricter or less strict, just depends on what type of conduct we're looking at. Okay, that brings me to my last point. The reflection on some of these aspects. Now, I think what we can safely say is the Code of Justice relies a lot on normative control as opposed to factual control. Now, I don't think that is very surprising, especially when we take into account also what Emanuela has said in the beginning and explained what the EU brought into the drafting process of the ILC. What I would like to point out, though, is that it is a very strict threshold of normative control. It is what Antonius before, in response to Vladislav's question, as strict normative control. So literally only if there is an obligation that does not leave discretion, then attribution shifts to the EU. But not in all these cases that came up in the drafting process of the ILC articles, like these areas where the EU has a lot of competence. That is actually not captured by this rule. Or, only if the specific measure imposes an obligation without discretion for the member states. What follows from that is that it is actually a rather restrictive threshold, and it leaves a bit the whole development of these rules leaves a little bit the question of the extent to which the rules have been developed consciously as attribution of conduct rules, or whether the sort of case-by-case approach brought about a sort of accidentally extremely high threshold. As a last point, there is a lot of areas in EU law outside liability law where it is really important to establish whether in a particular case we consider that the EU has acted legally speaking or the member state has acted legally speaking. It, of course, also concerns other procedures like judicial review. Actually, the definition of when conduct is attributable to the state also plays a role in the definition in defining when a rule is directly applicable, because there is a distinction between horizontal and vertical situations. I won't go into that now. My point is, I think that EU law would benefit from attribution of conduct rules that are more generally applicable, not just to liability law, sort of like what we have in international law. Now, the question whether or not these should be based on international law or should be EU specific, I think that that I can leave for the discussion. I think that is a lot of there is a lot of pros and cons to that, but that is something that's only the second step. First, the decision would have to be made to develop attribution of conduct rules that are generally applicable. That's it from me. Thank you very much for your attention.
Thank you very much, Professor Fink, for your excellent report, well-documented report. Now the floor is open for the panelists, but before I open the floor for you, I have a short question to Mrs. Gutman. Mrs. Gutman, do you have mentioned a new case law about the Ombudsman?
Yes.
What is about, this is a new law concerning Ombudsman after the ruling on Lambert's case at the beginning of 2000, I think. So what's news about the Ombudsman, the responsibility for acts of the Ombudsman?
Okay, thank you very much for your question. If I understand your question correctly, what you're asking is how has that case law advanced since that initial
evolution,
case?
yes. Is there an evolution of the case law?
So we've had several cases since Lambert's. I think the interesting things about Stalin, the most recent case that I mentioned, which of course I couldn't do justice to in the limited time, I think there note that you have a confirmation that even though the treaties themselves, as Melanie mentioned, only refer to institutions, which is interesting to me. I've always been curious why, whether it was an aftersight, what was really going on in those discussions on why they left Article 340 out and why they only dealt with 263 and 265, etc. But anyways, long story short is that I think this case was very interesting for several reasons. One, it shed light on the fact that the Ombudsman has important duties, but that it also, him or her, should be held accountable. That case, secondly, was important because you had a reversal of the General Court's approach. So there, the Court of Justice was able to say that you can't automatically hold the Ombudsman accountable for any action because the General Court had wanted to, in a sense, lower the threshold in the sense of having an automatic infringement, a mere infringement with no discretion. The Court of Justice held the Ombudsman, in a sense, to a higher threshold, which is looking at discretion. You see here, depending upon your vantage point, you see the Court of Justice, let's say, holding the line at where we're at, and you and I and all of us can argue about if that's too high or too low, etc. But also kind of making clear the established formula in case law, which was the General Court took a different approach. Does that answer your question, I think?
Thank you. Thank you very much. It was very interesting for me. Thank you. So,
there is no other question? I don't know.
yes, Mr. Sivira. No.
There is one. Wait.
Where? Written.
Would you read it, Professor Stangos?
Congratulations for your, is from Mr. Tollis. Congratulations for your presentations. I have a question for Dr. Fink. Can you file a claim against the staff member who committed the wrongful act Thank you for your time. Sincerely, Evangelos Toris, judge at the Maritime Court of Piraeus. So, can EU against the staff member who committed the wrongful act for which EU was obliged to compensate? This is addressed to Professor Fink.
So if I understand this correctly, the question is, well, if the EU is held liable for an act of a servant, as it is called in 340, servant sounds always a bit strange. Yeah, whether then the EU can sort of get the money back from the servant. Yeah, there is, maybe Kathleen knows more about this. There is a possibility also for servants to be liable for damage they committed. It's not 340, of course, but there is also a procedure where they can be held liable. But if I am not mistaken, but it's a long time ago that I read about this, the threshold is very different, so that it does not in all cases completely match the overlap with when the EU is liable. But maybe Kathleen knows more about this.
I think, Melanie, I would tend to agree. I would say 2 points, which is one, thank you very much for your question. What are you aiming at? I think Melanie, in a sense, covered a specific, let's say, limb of Article 340, where you have unit institutions and bodies, and then you have a special, it's the 4th paragraph, dealing with servants, which I agree, I always thought that was very strange as well. All kinds of staff. But importantly, and the reason why Melanie and I are both very interested in this, is that you have, if you're talking about the typical case, and we have, I think, several cases in the past where a servant does certain things, and then the question is, in a sense, do you trigger, is it in official capacity? Are you triggering the EU, or is it the servant's own personal capacity? But as a side point, I want to just note that you also have another debate or discussion or line of case law dealing with servants when it comes to, I'll give you an example of the Di Lusignano case, which is still, by the way, on appeal, where you have a case where the commission committed an unlawful act, and in a sense, the family members brought an action against the commission, the EU, for unlawful acts and conduct that caused their son, an EU official, a servant, to be killed on a mission. Now, when it came to the heirs and certain monies, that was a typical staff context arising out of the relationship that that staff member had with the EU. Whereas, interestingly enough, depending on what family member you're talking about, was it the father, was it the direct line children versus brothers and sisters, that created a discussion about what was covered and what route, what procedural avenue you take. Is it the typical ordinary damages action under Article 340, or are you in the staff context? Are brothers and sisters getting damages? Is that really arising out of the employment relationship? So that's why, in a sense, these cases, these staff or servant cases, like Melanie mentioned, is, I would say, a one line of that case law, which has its own, let's say, line of precedents, etc. But also, it's very interesting to me that we have a lot of, like Melanie mentioned, a lot of these older cases, which really need to be fleshed out further. And we're looking for, in a sense, a regeneration or some kind of refreshment that we don't have yet. And we're, in a sense, relying on these old cases to kind of make up for the lack of them when it comes to the current framework. So it's very interesting that this context kind of brings us into these different lines of the case law.
Okay, thank you.
I hope that answered the question.
I think.
Okay.
So is there another question? If we have not a new question.
I would love to ask a question to Melanie, which is, and I'm so happy because this area of attribution of liability, I wholeheartedly agree that it has been, let's say, methodologically blurred, and there really is a need for some case law to kind of pave the way in a more clear line. But my question is, you gave us a pregnant or provocative conclusion with regard to whether these rules that should be formulated, whether they would emanate from the international sphere or be established as a matter of EU law, but we could take from the international arena, etc. But to me, I was thinking about this in the sense that liability actions, we were left with, as you just point out, we were left with only one provision, Article 340, aside from the jurisdictional aspects, for which the union courts were charged to formulate rules based on the general principles common to the laws of the member states. So are we expecting too much for this to develop as a matter of case-by-case basis? Are we looking, is it going to emanate a lot in light of Article 340? Shall we, in a sense, formulate those rules in that same line in terms of, or do we really need to grab hold of other norms?
Yes, that's a really good point. I fully agree, actually. And that's why I would say two things, actually. One is, I think it probably cannot and should not be expected to develop solely out of liability law, which in a way now is the case. I think it should be an overarching framework with which you can then also answer these questions when they come up, for example, in composite procedures and judicial review. It should, the court also develops sort of attribution-like rules there, but they are not based on the same logic, at least not explicitly, than those in liability law. And I think there is several areas in EU law that would benefit from there being an overarching framework on attribution of conduct. So it could be consistent, but also so that we don't have to expect the court to come up with an entire sort of framework out of thin air and only for one specific, rather narrow area. So that is the one thing. And the other one, yeah, whether it should actually be based on the ILC articles, I think yes and no. Great lawyer answer. Because, yeah, yes, in the sense that I think there has a lot of intellectual work has been done in public international law when it comes to the concept of attribution of conduct, the possible thresholds, what they mean, what their consequences are, the upsides, the downsides. And I absolutely think that, yeah, in this conceptual sense, EU law should make use of that. Now, substantively, when it comes to the specific attribution rules needed, I don't think they necessarily should be based on the ILC articles, mainly because of the many difficulties with them that have been raised already now by our previous speakers.
Okay, thank you very much. The scheduled time for this panel has been completed. So I would like to thank all of you for your participation, especially the two rapporteurs, Mrs. Fink and Mrs. Gutman. So have a nice evening. Thank you.
Thank you, Professor Stangos. And I see there are these two questions by Jörg Polakiewicz and by